The man accused of killing 3 people and wounding 9 others at a Planned Parenthood clinic in Colorado Springs will face first-degree murder charges. Robert Louis Deer appeared in court Monday via video link from jail. The judge told Deer if convicted, he could be sentenced to life without parole or the death penalty. Doug Burns is a former federal prosecutor, and he joins me now on set. Doug, thanks so much for being with us.
My pleasure.
I mean, when you look at how long this siege played out and you look at all the eyewitness statements that are sort of coming out and the accounts of what happened, what kind of strategy can the defense pursue here?
Well, you never want to prejudge a case, but at the same time, history has taught us in these type of cases that this is going to be an extremely, extremely difficult case to defend, okay? And I think you hit it right on the head when you say, well, wait a minute, what are you going to do? You're going to hear overtones ostensibly perhaps of some kind of temporary insanity, maybe, you know, not fit to stand trial, that type of thing. I think, look, it's a straightforward triple state homicide. It's going to be extremely, extremely hard to defend. One thing I'd add, you know, federally, they were talking about that. You know, in order to make out a federal crime, it would have to be specifically by virtue of, you know, somebody's status. It adds like an element of motive, which you don't need in a state court prosecution. So my experience is, you know, and I know how DOJ works, they're not going to step in. They're going to let this be a triple state homicide. And then if, God forbid, something goes wrong, by the way, hypothetically, then maybe they might step in.
So for the defense, really, insanity is the only option
I would think so. I mean, I hate to say, you know, just a couple of days afterwards, you know, that's the only thing. I am a purist. I am a trial lawyer. And the reality is, you know, look at the evidence, look at the statements, look at the forensics, and so on. But again, when you see these type of mass outburst type shootings, it's usually pretty overwhelming because, as you said, Elaine, right out of the gate, you have a lot of eyewitnesses.
Right, right. Now, if you're the prosecutor here, do you go for the death penalty or you go for life in prison?
That's interesting because in Colorado, you haven't had anybody executed since 1997, Gary Lee Davis. So it's basically de facto out of play for almost coming up on 20 years. James Holmes didn't get the death penalty, obviously. So, I mean, I think they could use it ostensibly as a wedge, a plea bargaining tool, right? We'll take it off the table. But I don't think he necessarily realistically faces it.
What about venue? Sometimes, you know, lawyers will try to do a change of venue.
Absolutely. I mean, change of venue is a very, very typical pre-trial type strategy, saying, look, everybody's been so saturated, so inundated with information. That's not really the test, by the way. Test is, can you put it aside, start with a clean slate, and be fair? So I'm not so sure the judge would move it.
All right. There's also news on another case out of Chicago. I want to talk about that one. Jason Van Dyke, the officer charged with murder in the shooting death of Laquan McDonald, posted bail on Monday. So, you know, the videotape in this case, Doug, we were talking about this off camera.
Yes.
In some people's view, that is damning evidence.
Absolutely.
What is your take on that? Because not only is there that video, but there's also, you know, from multiple angles.
No. This is an issue that you have to put into historical context. I mean, you've had encounters, obviously, between law enforcement, you know, agents and people for years and years and years without a camera. Might be harsh to come out and say there's been a lot of untruths, but there have, okay? So let's not sugarcoat it. In this very case, as you told me, and you're so right, Elaine, they turn around and say, he lunged at us. That's what happened. Well, guess what? That's not supported in any way, shape, or form on the tape. People wiser than I, a couple of famous detectives I did some media with, they were saying, you know what? Cameras will show you what should be done. So I'm a big fan, actually, of the camera keeping the process honest.
Maybe we should mention we talked to Dan Herbert, the attorney, a couple of weeks ago. He said that, look, that never came from my client, that notion.
Oh, okay.
But let me just ask you this, because one of the things that was a big concern, and certainly we heard this on the day that the Cook County State's Attorney, Anita Alvarez, announced that there was this arrest, is the fact that this took place, the killing took place in 2014. The death happened in 2014. And here we are in 2015, more than a year later, talking about this. What? The Cook County State's Attorney said this is a complicated legal case, and it takes a while. It's not like a civilian to civilian murder.
It's unfortunate on some level. I mean, I don't want to be, you know, overly cynical. The fact of the matter is it's these type of cases do have a lot of pressure. There's a lot of scrutiny. There's media. I mean, we were talking about it. So I think maybe that makes it a little more difficult, and they want to, you know, dot I's and cross T's. That's not necessarily fair to the other case where they're not dotting the I and crossing the T for a year. But I will say that I agree with you, Elaine. I was surprised myself when I looked at the fact pattern and said, wow, that seems like a fairly lengthy period of time. But again, at the end of the day, I don't prejudge a case, but that tape speaks volumes about what happened, and I think it's also somewhat of a difficult defense case because excessive force defines itself as excessive force. The amount of shots, the fact that the decedent, the victim, wasn't necessarily lunging at somebody. And look, it's got to be tried fairly in a courtroom, rules of evidence, rules of procedure.
All right. If he is convicted of first-degree murder here, what is the possible sentence?
Well, it'll be 20 to life, basically, meaning that if he receives that sentence, 20 is the minimum before he's eligible for parole, and he could either be granted it or denied it for further parole hearings.
All right, we'll continue to watch that case. We also want to talk about the Freddy Gray case in Baltimore. Jury selection began Monday for one of the 6 police officers charged in Gray's death. You know, the city has been preparing for potential unrest in these cases.
Sure.
We saw Jeff Pegues talking to the police commissioner there. I mean, what do you expect? In cases like this now, there has already been some unrest, and now they're bracing for the potential of more.
Now, it's very, very difficult because, look, as I've told you, I'm a trial lawyer, I'm a purist, all that's fine and well, but when you get a case at this level, which can cause unrest in the community, potential violence, rioting, I mean, obviously we've seen it in other cases over the years. It's a very, very difficult thing. But as far as jury selection, real quick, people have to understand that sometimes they get the test wrong, Elaine. They're like, well, wait a minute. If everybody's heard so much about this, how can they possibly be a juror? That's not the test. The test is, can you put that aside, start with a clean slate, tabula rasa, be fair and impartial based on what you see and hear only in the courtroom? You've got to give an honest answer to that. You had said earlier in connection with one of the other cases, and you're right, change of venue. Okay, the defense in this case has tried twice to move the venue, not surprisingly. The counter-argument, I'm smiling because we lawyers always have a counter-argument, is, well, wait a minute, it's national publicity. So what's the difference if you move it from Baltimore to another venue? There's also saturated coverage. I kind of split that in half. I see arguments on both sides. But the point is the judge said, look, I'm not changing the venue. We're going to select this jury. We can't have a situation, think about it, where there's so much coverage that we can't have a trial. That's impossible. So you work backwards. Of course you're going to see the jury, but you've got to find people who are going to be open-minded.
And tell us why these 6 officers are being tried separately.
Well, that's what we call a severance. And sometimes there's a number of reasons for severances real quick. One is spillover prejudice. In other words, it's unfair. When you hear certain things that one did, we really don't want that spilling over to the other, so that's part of it. And then you have what are called antagonistic defenses, right? He did that, no, he did that, and in that case you're entitled to a severance. So those are some of the sort of simple concepts as to why you would get separate trials.
All right, Doug Burns, former federal prosecutor. Doug, thanks so much for your time.
My pleasure.